So let's go ahead and are you all set, Ms. Lipke, on your Lippert on your case?
Yeah.
Which one did you want to do first? We have the Zupke, we have the Sokchu matter, and then we have the Jews in Corp, and I think they're related, right?
Yeah, we should do the Jews Incorporated first if we could.
Okay. So that's the arraignment and the plea?
Yes.
Okay. And do we have a interpreter on that? All right. Let's go ahead and do that. We've got some other matters, but I think that one. All right, so ma'am, I'm going to swear you in. What's your name for the record?
My name is Teresa
But
Cho.
I'm going to have you get up here so we can hear you.
Okay. My name is Teresa Cho.
Okay, and how do you spell your last name?
It's CHO.
It's C-H-O.
Yes.
You got that? All right. I'm going to raise your right hand. Do you solemnly swear or affirm that you will make a true and understandable interpretation to the witness, that you will accurately interpret the statements made by the witness to the best of your ability?
I do.
All right, thank you, ma'am. So this is the time set for Jews Incorporated, and I think we have a new amended information. Is that correct?
We actually filed a brand new complaint.
Okay,
I believe that we decided because there was a different spokesperson for the company that we needed to start over from the beginning.
all right. And so we need to arraign the individual on it, and then we'll take a guilty plea to circuit court. All right. And I have, just so we're working from the same complaint to make sure, I have Jews Incorporated doing business as Makamoto. Yeah, so is that the correct complaint?
Yes, and it should be dated September 28th.
September 28, 2022. All right. All right. So we're on the record in docket 22-02630. And ma'am, appearances for the record.
Elizabeth Lippett on behalf of the people.
Dennis Kent on behalf of the defendant, who's present with me in court.
All right. And do you want me to refer to your client as Jews Incorporated or by name as representative of?
As the court pleases.
Okay, so ma'am, your name for the record.
My name is Hwa-Jang Ju.
Okay, and you will be going through the arraignment and plea as doing business as Makamoto.
그래서 재선임으로 마키모토로 이름으로 해서 사업을 했습니다. Yes.
Okay, thank you. So this is the time for arraignment. I'm going to read through the charges.
재선임으로 지금 할 텐데 지금 혐의를 얘기를 하겠습니다.
And then I'll read you some felony rights in regards to the arraignment on the charges.
그리고 이제 또 권리에 대해서 얘기를 해드리겠습니다.
So the summons felony indicates that on or about April 16th, 2013,
그래서 2015년도 4월 16일 정도 때
through October 31st, 2019,
2019년도 10월 13일까지
that Jews Incorporated doing business as Makamoto
주스 인코퍼레이션 그 회사가 마키모토 이름으로 투자를 영업했습니다.
Wajang Ju owner, that Jews Incorporated doing business Nakamoto is a Japanese diner
주스 인코퍼레이트에서 사업을 했고 마키모토는 일본 식당입니다.
located in Auburn Hills.
아버님이 있고요.
And for tax years 2014 through 2017,
그래서 2014년과부터 2017년간의 그 세금 보고 기간 동안
Jew sales tax returns were filed with the Michigan Department of Treasury.
그래가지고 주스 인코퍼레이트에서 미시간주에다가 세금 보고를 했는데요.
With less annual income reported than that reported to Treasury.
그 세금을 받는 그 수입이 적게 나왔습니다. 적게 보겠습니다.
By credit card companies via Form 1099K.
99K가 크레딧 카드로 보고가 됐는데.
Based on the data reported by credit card companies and not including cash sales.
캐시로 세일즈를 빼고 크레딧 카드로만 하는 세일즈가 아니고.
Jew sales were underreported by approximately.
브랜드가 이 정도의 액수가 더 낮게 보고됐습니다.
198,153.
동안 8,153불 정도가 낮게 보고가 됐습니다.
Did you want to?
Your Honor, I do have a copy of the complaint, right? I didn't know if
And
it would be easier for her to be able to.
It might be if she has something to look at. Yeah, for the numbers purposes. That's a great idea.
Thank you very much.
Just for the 2015 number.
Thank
Yeah,
you.
that might be easier to refer to as I read through them.
Thank you very
All
much.
right.
그래서 이 정도의 돈이 더 낮게 보고가 됐습니다.
Right, and that was in 2015.
이게 2015년이고요.
And 150,747
747불이
in 2016.
2016년도에 더 낮게 보고됐고요.
And 259,730
25,9,730불이
in 2017.
2017년도에 더 낮게 보고됐습니다.
Jews' annual sales tax returns were not filed for tax years.
그리고 주스 인코퍼레이트에서 그 다음에 연도수는 제출하지 않았습니다.
2018
2018년도,
or 2019.
2019년도
Yet credit card companies reported Jews' sales of 631,264.16 cents.
그 크레딧 컴퍼니에서는 63만 1,264불 16전으로 보고되고 있습니다.
In 2018,
2018년도에
and 622,514
62만
in 2019.
1,514불이 2019년도에 보고가 되었습니다.
Jews' corporate income tax returns were not filed for tax years 2018 or 2019.
하지만 주스 인코퍼레이트에서는 2018년도나 2019년도에 세금 보고를 하지 않았습니다.
Right. So the allegations would include in count one, did with intent to defraud or evade the payment of tax.
그래서 첫 번째 혐의는 텍스를 세금 보고를 안 하려고 한 거고요.
A part of a tax
세금 보고를 세금 보고의 그 수입의 전체가 아닌 그 한면만
permit to be made for Jews Incorporated doing business as Makamoto.
마키모토로 이름을 해서 주스 인코퍼레이트에서 사업을 했습니다.
A false statement in a 2015 sales tax.
2015년도에 세금 보고가 생겼습니다.
That's contrary to the laws of the state of Michigan.
그거는 미시간법에 반대되고요.
205.27 parents 1 parent C.
205.27 법 미시간 법에 어긋납니다.
In count two,
첫 번째는
did with the intent to defraud or evade the payment of a tax.
세금 보고를 잘 제대로 하지 않았고요.
Or part of a tax,
부분적인 세금의 부분을 잘 하지 않았습니다.
permit to be made for Jews Incorporated doing business as Makamoto.
Jews Incorporated가 마틴노블 이름을 담아서 사업을 할 때
A false statement in a 2016 sales tax,
2016년도에 세금 보고를
contrary to the laws of the state of Michigan.
미시간주에 어긋나게 법에 어긋나겠습니다.
That's 205.27, parents one, parent C.
그 법이 205.27 1C 미시간 법에 어긋났습니다.
And that's a felony, 5 years and or $5,000.
그리고 난 중범죄도 5년 동안 감금까지 감금될 수 있고,
It didn't count three,
그게 세 번째는요.
with the intent to defraud or evade the payment of a tax.
그 세금 보고를 잘못했거나 소부했습니다.
Or part of a tax,
아니면 세금 보고의 부분을 잘못했습니다.
permit to be made for Jews Incorporated.
주식 코프도 이름을 주식 코프 회사가 됐습니다.
Doing business as Makamoto.
마키모로의 이름을 걸고
A false statement in a 2017 sales tax,
2017년도에 세금 보고가 됐습니다.
contrary to the laws of the state of Michigan.
미시간 법이 어긋났습니다.
205.27, parents one, parent C. That being a felony, 5 years and or $5,000.
그거는 5년 만에 감금될 수 있고 중범죄로서 5천까지의 벌금을 낼 수 있습니다.
Didn't count four,
그리고 네 번째
with the intent to defraud or evade the payment of a tax.
세금을 속였거나 잘 내지 않았습니다.
Or part of a tax, fail or refuse file 2018 sales return or payment as required by the laws of the state of Michigan.
2018년도에 세금을 법적으로 내야 되는 것을 하지 않았습니다.
That's contrary to the laws of the state of Michigan.
미시간법에 어긋났는데요.
205.27, parents one, parents A.
그리고 5.27 1A 부분을 보겠습니다.
Further in count five,
다섯 번째
did with the intent to defraud or evade the payment of a tax.
세금을 속였거나 잘못했습니다.
Or part of a tax,
아니면 세금을 폭력적으로 잘못했습니다.
fail or refuse to file 2019 sales return,
2019년도에 세금 보고를 하지 않았습니다.
or payment as required by the laws of the state of Michigan.
세금 보고를 지키지 않았습니다.
Contrary to MCL 205.27, parents one, parents A.
205.271A 보고를 받았습니다.
That's a 5-year felony and or $5,000.
또는 5년 동안에까지 감금될 수 있고 5천까지의 벌금을 낼 수 있습니다.
In count six,
여섯 번째요.
did with the intent to defraud or evade the payment of a tax.
세금을 속이려고 하거나 아니면은 내지 않으려고 했습니다.
Or part of a tax,
세금의 부분을 내지 않으려고
fail or refuse to file 2018 corporate income tax.
그래서 2018년도에 영업 세금을 안 내려고 했습니다.
Or payment as required by the laws of the state of Michigan.
미시간 주 법대로 내지 않았습니다.
Contrary to 205.27, parents one, parents A.
205.27 1A를 얻었습니다.
That being a felony, 5 years and or $5,000.
여기 5년 동안 감금될 수도 있고 5천까지의 벌금을 낼 수 있습니다.
And did in count 7? Did with the intent to defraud or evade the payment of tax?
세금 보고를 하지 않거나 세금을 내지 않으려고
Or part of a tax? Fail or refuse to file 2019 corporate income tax return?
2019년도에 영업사업 영업세금을 내지 않고
Or required, or a payment as required by the laws of the state of Michigan?
기간 주법에 따라서 내지 않고
That's contrary to MCL 205.27, parents 1, parents A.
그게 MCL 205.27 부법을 보겠습니다.
That's a felony, 5 years and or $5,000.
이게 적용되고 5년 동안 감옥까지 감금될 수도 있고 5천 불까지의 벌금을 낼 수 있습니다.
Do you understand the nature of the charges that are brought against you, ma'am?
지금 내 혐의를 선생님의 그게 혐의를 내보는 것을 이해하십니까? Yes.
That's yes? Okay. I'm going to walk you through some of the rights you have in this regard concerning these arraignment on the felony charges. So these are the rights you'll be waiving in order, well, these are the rights you have on the felony charge today. Okay, ma'am?
지금 이제 앞으로 선생님이 가지고 있는 권리를 조금 설명을 드릴 텐데요.
You understand that these 7 counts all include a 5-year penalty and or $5,000 as the ultimate consequence.
그래서 일곱 개의 혐의가 다 5년 동안까지 감금될 수도 있고 5천 불까지의 벌금을 낼 수도 있다는 건지 아십니까? Yes.
Okay. You understand that you have the right to have a trial of any kind by jury or bench trial?
그래서 판사 앞에서 재판을 받든지 아니면 대신 앞에서 재판을 받을 수 있는 권리가 있다는 걸 아십니까? Yes.
Okay, you have the right to be presumed innocent until proven guilty.
그래서 그 검사 측에서 무죄를 입증하기까지는 무죄인 것을 이해하십니까? Yes.
You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty.
그래서 검사 측에서 간단한 의심을 가지 않을 정도로 무죄라는 것을 입증해야 된다는 것을 이해하십니까? Yes.
You have the right to have witnesses brought for you for your defense at trial.
그래서 그 재판을 할 때에 본인을 위해서 그 증인을 불러가지고 할 수 있는 기회가 그 권리가 있다는 것을 이해하십니까? Yes.
You have the right to have any witnesses questioned by your attorney, Mr. Kent.
그 어느 증인이 올 때 선생님의 변호사가 질문을 하고 질문할 수 있는 권리가 있다는 것을 이해하십니까? Yes.
You have the right to remain silent during trial.
그 재판을 할 때 본인께서 아무 말도 안 해도 된다는 것을 이해하십니까?
And that silence cannot be used against you.
그 아무 말도 안 한다고 그것이 본인에게 해가 되지 않는 것을 이해하십니까?
You also have the right to choose to testify at trial if you wish to.
그리고 원하시면은 재판하는 동안에 또 증언을 하실 수도 있는 권리가 있다는 거 아십니까?
You're of course represented today by Mr. Kent.
미스터 켄씨가 본인을 대표하십니까? 미스터 켄씨께서 선생님을 대표하십니까? Yes.
Okay, and then I'll dispense with any address or concerning we can transfer file. So at this arraignment, this is the arraignment, will automatically enter not guilty plea at this point in time.
그래서 이걸 지금 하고 있는 게 재산인데 이 재산행부 지금 이때는 지금 유죄가 아니라고 일단은 얘기하고 있습니다.
since we're moving right on from here, that'll end the arraign of any of the questions asked of the defendant in this case, Ms. Lippett.
No, Your Honor, thank you.
질문이 없습니다.
Mr. Kent. All right, so do we have negotiations? Do you want to place the plea agreement on the record?
그래서 지금 수사한 내용이 있습니까? 그래서 그것을 기록에다가 기록할 수 있게끔
Your Honor, in as much as we would call it a plea agreement, the agreement is for Jews Inc. to plead guilty as charged and agree to a restitution order. I think it's in the plea packet. A restitution order of $223,000, $223,234 with credit for $75,699.
like to numbers
All right,
I'm going to repeat the numbers.
yeah, just, and for me too, I have 2,223,234.
223,234,
And credit for,
credit for 75,699.
후보하는 그 명령이 있었는데 22만 3,234번 중에 75,699개를 획득했습니다.
all right, so so Mr. Kin, is that your understanding as plea is charged with restitution and then the rest to be decided in circuit court as this court moves forward?
Yes, Your
as this case goes forward.
네, 그래서 이해하십니까? 회복할 수 있는 그 돈을 내시고 또 이 사건이 부분으로 올라가고 그래서
Anything else, Ms. Lippett?
No, Your Honor.
Okay. All right, so you understand you have, once again, felony rights in this guilty plea, correct?
그래서 이 중범죄에 대해서 여러 가지 권리가 있다는 걸 이해하시죠? Yes.
And I'm going to walk you through these rights again, and then we'll go through the factual basis.
그래서 이 권리들을 또 이제 얘기를 하고 그다음에 그럴 만한 증거가 있나 보겠습니다.
All right, ma'am? All right, so if I accept the plea, yeah. So if I accept the plea, you will not have a trial of any kind in this case.
그래서 이 협상을 받아들이시면은 이제 이 사건에 대한 재판이 없습니다.
And you'll be giving up the rights, the following rights, if we accept the plea today, okay, ma'am?
이제 인정을 하시면은 이제 지금 얘기하시는 그 권리를 얻고 이제 포기하십니다.
You'll be giving up the right to be tried by a jury.
대신은 앞에서 재판을 받으시는 분이 있는데 그렇습니다.
You'll be giving up the right to be presumed innocent until proven guilty.
선례팀에서 유죄인 것을 입증하실 때까지 유죄인 것을 그 권리를 포기하십니다.
You'll be giving up the right to have the prosecutor prove or the attorney general prove beyond a reasonable doubt that you are guilty.
검찰 측에서 합당하게 의심이 가지 않을 정도로 증명해야 되는 그런 권리.
You'll be giving up the right to have any witnesses appear on behalf of your trial.
선생을 위해서 증인을 부를 수 있는 그런 권리를 포기하십니다.
You'll be giving up the right to question any witnesses brought against you.
선생님에 대해서 이제 증인이 나왔을 때 그 사람을 질문할 수 있는 그 권리를 부여주시게.
You, of course, are representative of Mr. Kent, and he would be here to cross-examine or contest any charges brought against you.
그래서 미스터 께서 선생님을 제출하시고 그리고 이제 이 훈이가 선생님을 선생님께 같이
You'd be giving up the right to have the court order any witnesses to appear on your behalf.
선생님을 위해서 증인이 와서 증언을 할수 있는 그런 권리를 부여하시고
You'd be giving up the right to remain silent.
아무 얘기도 하지 않아도 되는 그런 권리도 부여하십니다.
You'd be giving up the right not to have that silence used against you.
아무 얘기도 하지 않다고 그것을 선생님에게 나쁘게 사용되지 않는 그런 권리도 부여하십니다.
And you'd be giving up the right to testify at trial if you choose to testify.
그리고 재판에서 선생님께서 선생님을 위해서 증언할 수 있는 그 권리도 부여합니다.
If the plea is accepted, you'll be giving up any claim that the plea was a result of promises or threats.
그래서 만약 이 유죄를 인정한 거가 선생님께서 받아들이게 되면은
That were not disclosed to the court at the plea proceedings, at these proceedings.
그게 선생님 스스로 자신에서 한 거고 누가 뭐 협박하거나 약속을 하지 않고 한 것이.
You'd be giving up the right to claim that this is not your choice to plead guilty.
그래서 이게 선생님 스스로 원해서 하십니다.
If your plea is accepted, you'll be giving up any right to appeal what would happen at trial.
그래서 이 권리를 포기하시면은 저기 유죄를 인정하시게 되면은 나중에 형사 재판을 할 수 있는 그 권리도
You won't be having a trial today because you're pleading guilty.
그래서 오늘 지금 재판이 없습니다. 왜냐하면 선생님께서 유죄를
And any appeal from a conviction and sentence pursuant to the plea would be by application to leave and not by right.
그래서 이 모든 것은 선생님의 권리에 권리로 인해서 다 없어지는 게 아니라 그냥 이게 적용되기 때문에 그렇게.
Beyond the plea agreement, have you been promised anything that we haven't talked about today?
지금 일상 이외에 다른 뭐 약속을 지금 얘기하지 않은 그 약속을 가진 적 있으세요?
That's a no? Okay. Are you pleading guilty because you are guilty?
Your Honor, I just would like to clarify
Sure.
that she's foregoing rights for the company,
Company.
not for her in
Correct.
an individual capacity.
Right, just on behalf of the company,
On
is how you're
behalf.
speaking.
지금은 이거는
Yeah.
이제
Thank you, Mr. Kim.
그래서 이것이
Are you pleading, you're pleading guilty because you are guilty on behalf of the company?
그래서 지금 유죄를 선택하는 것이 지금 이 사업을 대출해서 잘못했기 때문에 유죄이기 때문에 유죄를 인정하시는 겁니까? Yes.
All right, ma'am, I'm gonna have you raise your right hand.
그러시고요.
So on behalf of the company doing business as Makamoto, do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
지금 주 컴퍼니를 대표해서 마키모토 그 식당을 이름으로 지금 대표해서 지금 사실과 모든 사실과 사실만을 얘기하시고 설치하십니까? Yes.
I'm gonna bring your attention back to April 16th, 2013.
그래서 2013년도 4월 16일로 지금 이제 되돌아가서
To October 31st, 2019, in regards to all 7 counts today.
2019년도 10월 13일까지 그 기간 동안에 그 7가지의 그 카운트를
On behalf of Jews Incorporated, doing business as Makamoto, and yourself, Wajun, as owner in count one, did you fail to make payment or part of a payment in regards to your 2015 sales tax, or make a false statement in regards to those sales?
주스 인코퍼레이트를 대표하고 마키모로의 이름을 사용해서 2015년도에 세금 보고나 아니면 세금 보고 중에 부분을 잘못 세금 보고하셨습니까? Yes.
So yes, okay. That's contrary to the law, state of Michigan 205.27, parents 1, parent C.
이게 그 미시간법 205.27에 건드립니다.
And that was failed to pay in the city of Lansing.
그거는 이제 랜싱 시에다가 내지 않은 거죠.
Any questions in regard to count one?
No, Your Honor.
All right. You let me know if there's any questions, because you know this case better than I do, but
Sure.
all right. As to count two, so I find the factual basis for count one to be knowing, voluntarily, and accurately made. We'll go to count two.
그래서 이 지금 차집이
In count two, did you, with the intent to defraud or evade the payment of tax or part of a tax, to be made by Jews Incorporated on making a false statement on your 2016 sales tax?
2016년도에 그 세금 보고를 주스 그 컴퍼니 이름을 사용해서 주스 컴퍼니를 대표해서 그 마키모토 이름을 사용해서 세금 보고를 잘 했습니다.
That's yes, ma'am. Okay, so that was is that evade or the intent to defraud? What's the theory here?
Either evade is fine.
Okay, so that's the evade of the payment of tax in the city of Lansing.
랜싱 시에다가 세금을 다 보고를 잘
It's a yes, ma'am. All right, and that's contrary to the law, state of Michigan 205.27, parents 1, parent C.
미시간법 205.271C입니다.
All right, so I find the guilty plea to count two to be knowing, voluntarily, and accurately made. As to count three,
그래서 유죄를 두 번째 혐의에 대해서 유죄를 인정한 것이 스스로 법원에서
did you evade the payment of tax in the city of Lansing, doing business as Jews Incorporated, doing business as Makamoto, in a 2017 tax return or sales tax?
2017년도 세금 보고를 주스 인크를 대표로 마키모토 이름을 보고 한 것에 세금 보고 잘 못하셨습니까? Yes, we didn't do it.
All right, and that was contrary to the law, state of Michigan 205.27, parents 1, parent C.
그것이 미시간법 205.27법을 어긋난 거죠? Yes.
All right, I find the factual basis to count three to be knowing, voluntarily, and accurately made. As to count four, did you evade the payment of tax or fail or refuse to file a 2018 sales return or payment as required by the laws of the state of Michigan?
네 번째 혐의 2018년도 그 세금 보고를 잘 안 했습니까?
Is that a yes?
네.
Yes.
Yes.
That's contrary to 205.27, parents 1, parents A.
이게 미시간법 205.271A를 어긋나는 겁니까? Yes.
I find the factual basis for count four to be knowing, voluntarily, and accurately made. In count five, did you intend to evade the payment of tax or part of a tax by failing to file a 2019 sales return?
2017년도에 세금 보고를 잘 못했습니까? Yes.
That's in the city of Lansing, failing to pay on behalf of Jews Incorporated, doing business as Makamoto.
그거는 주스 잉크를 대표해서 마지막으로 이름으로 영업한 것에 대한 세금 보고를 랜싱 시에다가 내지 않는
That's contrary to the laws of the state of Michigan.
그게 미시건법에 어긋났습니까?
That's 205.27 parents 1 parents A.
이게 205.27 1A 법을 어긋났습니다.
And in count 6, did you intend to defraud or evade the payment of tax by failing or refusing to file a 2018 corporate income tax doing business as Makamoto?
그래서 여섯 번째 혐의 2018년도 세금 보고를 주스 잉크를 대표하셔서 마트보로 이름으로 영업한 데 대한 세금을 잘못하셨습니다.
That's a yes, ma'am. All right, and that was required by the laws of the state of Michigan and contrary to 205.27 parents 1 parents A.
이것은 미시간법에 어긋났고 그 법은 205.27을 1A를 어긋났습니다.
Okay, I find factual basis for count 6 to be knowing, voluntarily inaccurate. As to count 7, did you evade the payment of tax by refusing to file a 2019 corporate income tax doing business as Makamoto, contrary to the law of the state of Michigan?
2010년도 세금 보고를 주스 잉크를 대표로서 마트보로 이름으로 세금 보고를 잘 안 하신 것을 안 했습니다. Yes.
Okay, that's contrary to 205.27 parents 1 parents A.
이게 205.71A를 어긋났습니다. Yes.
Ms. Lippett, any questions about the factual basis on counts 1 through 7?
Yes, I'm sorry, go ahead.
1번이 1번부터 7번까지의 무슨 질문이 있습니까?
Your Honor, I'd just like to verify that each of the violations in counts 1 through 7 occurred in the city of Lansing.
Did all of these counts occurred in the city of Lansing, ma'am?
그래서 이 모든 것이 랜싱시에서 일어난 겁니까? Yes.
Anything else?
That's it. Thank you,
Okay.
Your Honor.
Mr. Kent, anything concerning the factual basis?
No, Your Honor.
All right. I find the factual basis be knowing, voluntary, and accurate. I accept the plea as to counts 1 through 7. The case will now continue to circuit court. You've pled guilty to felonies in district court, and now the case will move on to circuit court, where you should keep in contact with your attorney, Mr. Kent, and he'll provide you with any further hearing dates concerning this matter. Okay, ma'am?
그래서 지금까지 유죄를 소송한 것이 혼자서 스스로 원해서 한 것으로 인정하고 이것이 이제 유죄를 인정한 것을 알고 그리고 이제 이 사건이 이제 앞으로 고등법원으로 올라갈 것입니다. 그래서 변호사님께서 다음에 법원에 공개 날짜를 위해서 정보를 드립니다.
All right, so in regard to this, the bond conditions, because we're taking the original file, and this is doing business as, they continue the same, the bond conditions. I have to set a bond on the new arraignment, but it's whatever the bond was on the old one, which I think was a PR bond, and they're doing business. So PR bond, $500.
아까 보석금이
Do you have any objection to that, Ms. Lippett?
No, Your Honor.
Okay, Mr. Kent?
옛날
All right.
보석금 제한이랑 똑같대요. 그래서 그게 개인 보석금 500불로 해서
Anything else? So this case is now in circuit court, bound over in order to get sentenced in circuit court. Anything else for the record on this file 2202630? Ms. Lippett.
No, Your Honor.
Anything, Mr. Kent?
Your Honor.
All right, ma'am. Good luck to you. Anything and restitution wise, we're all set.
Yes.
Okay. All right. So I'll make the notes in the file and we're all set on this file.
Okay, thank you, Your
Thank
Honor.
you.
Your Honor, appreciate your patience.
All right. Okay. So, and then I just went ahead and wrote the restitution amounts. I'm gonna leave that. That was.
Yeah, it was very, very helpful.
Sure.
I forgot to do this.
All right.
Trying to tell
And thank you for your patience and interpretation today.
you. You're welcome, my pleasure, Your Honor.
All right, we're on the record in docket 21-03189. That's people of the state of Michigan versus Siak-Wan Chu. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Elizabeth Lippett on behalf of the people.
Hello, Judge Jordan Zupke on behalf of Mr. Sequan Chu, who's to my right, present in court.
And sir, you are Siak-Wan Chu?
Yes, sir.
All right, thank you. Ms. Lippett, this time set for a preliminary examination. How are we proceeding today?
Your Honor, the people are making a motion to dismiss the charges in full.
Okay.
I
So
have
just-
a-
Yeah, so dismiss all charges without prejudice, no objection, of course. And then you have something for me to sign?
Yes, I do, Your Honor. May I approach?
You certainly may. Thank you.
Thank you.
All right, so Mr. Chu, the motion was made to dismiss all counts today. It's made without prejudice, which means they could bring it back. Most likely they would not. It's all done for today. I'll sign the nollie pros that's set in front of me. All right, sir?
Yes.
All right. Anything else for the record, Ms. Lippett?
That's all, Your Honor.
All right, anything else, Mr. Zupke?
May I have a copy of that for my
You
file?
can.
Judge?
We'll make a copy for you. You're all set, Mr. Chu. Thank you.
Thank you, sir.
Thank you, Judge.
Thank you. The record in docket 21-00626. The city of Lansing versus Stanley McNeely. Will the parties please introduce themselves for the record? Ms. Rashmawi, there's no restitution in the matter, right?
No, there's no.
Okay. All right. So Ms. Sutter, your appearance?
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter, appearing today on behalf of Mr. McNeely, who is standing to my right.
And sir, you are Stanley McNeely?
Yes, sir.
Okay. Ms. Sutter, you've had the opportunity to go through the, there was a pre-sentence report done and then a victim report done in the matter. That was dated October 25th, 2022. You've had the opportunity to go through that with your client?
Your Honor, I have one dated, the cover letter signed by Ms. Duhosky was dated September 29th of 2020.
Take a look at this October 25th, just to make sure that we're on the same page.
Thank you.
Yes.
Oh, yes, for today's for the 25th is prepared. on
Okay.
29th. We're looking at two different boxes. I
All right,
apologize.
just to make sure, Any additions, deletions, or corrections?
There's one correction, not to her cover letter. She indicates that she stands by the original recommendation, so that's what there is a correction to, particularly within the employment section. At the time this was prepared a little over a year ago, Mr. McNeely was not working. At this time, he is employed full-time at Kirchhoff's Auto. He does the night shift there, and as I said, that's full-time employment. He's been there for he was there for quite a period of time. He had a short break off while he was seeking other employment, and he's back working there now.
And how do you spell that, Kurt? How do you spell-
K-I-R
K-I-R
C-H-O
C-H-O
F-F-S.
F-F-S.
I had to ask too.
Was I right?
There's no S? There's just Kirkhill? I'm doing
Just-
the Michigan thing of adding an S.
Okay, so no S.
Thank you.
Allocution, Ms. Sutter.
Thank you, Your Honor. As I briefly stated, the majority of this report was prepared well over a year ago. In that period of time, a number of things has changed, as is to be expected within a year, but in my opinion, the most significant thing that has changed in this last year is Mr. McNeely's mental state. I think it's quite apparent to the court where he was in terms of his thought processes, his own mental health journey. I think it's quite apparent where he was a year ago, and that has dramatically changed. Mr. McNeely has been a person who has been in incredibly good contact with me about the efforts he's making in his own life to continue moving forward, to seeking better things for himself. That started with employment. As I stated, he is working full-time at Kirchhoff Auto. That's good employment for him. And despite the fact that it is good employment, he's not satisfied with that. He wants to keep moving upward and onward. He has been seeking to return to work using his CDL license, doing work for the DOT as a sensitive, let's get this right, it's not sensitive materials. Apologize. That wasn't sanitation, I do apologize. I remember the sensitive phrase. Safety sensitive position. I apologize for trying to find that. That's work that he is trying to do now. That would involve a number of things through the DOT and the DOT clearinghouse. And if your honor is willing, I do have a letter that was prepared by a Marjorie Briggs. She's a licensed LMSW, CAADC, and a substance abuse professional. I have also given a copy of this letter to Ms. Rushmore.
All right. Let the record reflect. I'll read that and then I'll just add it to the pre-sentence report.
Thank you, Your Honor. And what's contained within that email is a little bit of the summary of the efforts that Mr. McNeely has been making and intends to continue making. As I said, he's seeking out better employment for himself using his CDL license to do work for the Department of Transportation, doing that safety sensitive position, meaning transport of those kinds of materials. It's work he has been previously qualified to do, and he's been working to get back to the position with his life, with his Secretary of State position, as well as his case positions, to get back to that kind of work. And he's had discussions with Mrs. Briggs about how to do that. And she's laid out quite clearly for myself as well as the court, the path forward to that. And that's a plan and a path that Mr. McNeely intends to take. He's only waiting for today's hearing to conclude to begin on that path. It's quite extensive in terms of what would be required of him, and it does in particular include things like drug and alcohol testing that is done through labs that are often used by the court. It also includes a couple of other things like classes, like substance abuse assessments, all these kinds of things we would typically see probation do. He would be required to do as any part of that DOT clearinghouse to get back in the position of working as a CDL. As I said, the thing that's changed most dramatically in the last year is Mr. McNeely's mindset. And at the time this report was prepared, given his mindset, the probation department made a very specific recommendation. What they recommended was 30 days in jail and then a release to residential treatment followed by 18 months of probation. I think I can understand where that originally came from at the time, but I think had he been in the place he is now a year ago when he spoke with them, it would have been a very different recommendation. I also, just for the record, will note that her cover letter, Ms. Dukoski, notes that Mr. McNeely has credit for 8 days. I don't believe that's correct. He was held without bond between September 2nd and September 16th. He was then issued a $3,000 10% bond on the 16th that was posted on October 7th. I believe that would give him credit of at least 35 days. I think he might have some time accredited to him from this case back a year ago, but at the very least between the bench warrant arraignment in September and now, he would have credited for 35 days. As I said, the original recommendation was for 30 days in jail. He's already served over that amount. And I think even without that credit, I no longer believe that jail is the most appropriate place for Mr. McNeely. I can see why the probation department may have suggested that at the time, but I think given the work that he's doing, has done, and continues to do, I think the more appropriate position for him is something on a term of probation where he is continuing to work and grow on the things he's already done, to continue fulfilling these things he's already set into motion for himself, that being employment, that being mental health support, as indicated by Mrs. Briggs in her letter. There's a lot of really really strong support and resource systems that would be required to that employment path he's taking. And I think that if he were to be put on probation, it would obviously comply with any of those terms of probation and would kind of serve a dual purpose in terms of how this case is appropriately handled, as well as how he moves forward on his own. I think it's quite difficult to do this kind of work, and he's done it on his own. I understand that it's not great to be here standing a year later after a court hearing was missed, and it's obviously never a great decision to have led us to that point. But in the meantime, he hasn't just let it all go. He hasn't given up, as I think was probation's concern. He at some point took a look at his life and decided he deserved something more, and something more was required of him, and he took the steps to start doing those things. And I think that's commendable. And I don't want to sabotage the efforts he's already been making. I'd like to see him continue and thrive on those, because I think he has the capacity to when he has hope. And I think at this point, he's found himself some hope. And if the court is willing to, what I would suggest in the alternative to the original recommendation by probation is some term of probation, perhaps 6 to 9 months, where he is complying with all of the requirements of this DOT clearinghouse pathway, as well as meeting with probation agents. I would hope that probation would be satisfied by any of the drug and alcohol testing he is doing with DOT and with Mrs. Briggs, perhaps satisfying a dual purpose there. But I think at this stage, that's the more appropriate path for him in terms of serving himself as well as the community. Thank you.
Mr. McNeely, anything you would say to the court before the court passes sentence?
No, Your Honor.
All right. I think Ms. Sutter's summed up the case history here. What's the credit? If you can tell.
I think it's 42 days, but I'm not sure.
All right. I just want the JOS to reflect the credit here, because it was
Ms. Sutter's correct. He has at least 35 days.
At
I think
least
with the
35
other candidate,
days.
It's 42, but I'm not really sure.
I figured somewhere between the 35 and adding 8 or 7, maybe. I couldn't quite tell. I figured conservatively 35.
Well, Mr. McNeely, I looked at your case, and Ms. Sutter's right. A year after the fact is not a great place to be, but you've done good things here. However, you may or may not like my sentence, okay? And the truth be told is sometimes going to jail is easier than being on probation, all right? I've had this conversation with Ms. Sutter. Probation's not for everybody, all right? But I think in your case, you're a young man, probation can be a good thing. I think from reading the judgment of sentence, from reading the indication from Ms. Briggs, there's a lot of resources and options out there for you if you choose the right ones. All right. Unfortunately for you, I'm not worried. This is unfortunate. I'm your problem for the next year. Okay. I'm your problem. It's not your probation officer. Ms. Sutter's going to be here on your behalf, but I'm your problem. And that's because I'm worried for you in the long term. The next year, if you don't take options and resources that we make available to you, I'm stuck with the last thing I want to do, which is to incarcerate you. I'm not incarcerating you today. Okay. I'll tell you that right now. You've made good decisions somewhat. You're employed. I want you to build on all that. I want you to keep on making good decisions. I want you to listen to people who are looking to help you, not be destructive to you. Okay. And that's important. All right. That's important. Now, at the end of the day, I'm okay being the bad guy. So if you don't make good decisions and good options, you start taking away my resources. And I have a lot of them, and we're here to help you. But if you don't do and take advantage of these things, I have nothing less but to incarcerate you. And that's the last thing I want to do. I just don't see the world that way. I see the world with you being productive and going out there and doing what you're supposed to do. So I'm not worried about the next. I'm going to put you on probation for a year, okay? The next year, all right? 1 year. Now you may be able to get off. We'll talk about that. But for the next year. Now, if you do everything you're supposed to in the next year, you take advantage of these options, then 4 years from now, I'm not worried about you. You're going to make good decisions. You're going to take these options that are good for you, and you're going to make the right decisions. And that's a long-term look at you, okay? It's a long-term look. If you make short-term bad decisions, you're gonna answer to me, all right? And we'll have this conversation as many times as we need to, but but ultimately, it may start with a weekend in jail, it may start with 3 days in jail. I don't want any of that. What I want you to do is start taking care of yourself, right? Start taking care of yourself and making good decisions. I agree with Ms. Sutter. I don't believe jail is necessary at this time. I believe you've presented in a way, and there's enough good things said about you that would indicate that you're right on the verge of taking this and making all the good decisions necessary. I believe Ms. Sutter believes that. I certainly believe that. And so I want you to prove us right. Okay, I want you to prove us right. So I'm going to suspend any jail time. So that'll be, I'm going to give you 35 days credit jail. I'll suspend upon successful completion of probation any further time. This is on the guilty plea to count 1, which is operated while intoxicated, and count 3, which is open alcohol in a vehicle. You're going to be accountable for these, all right? You broke the law. So I don't want anybody leaving my courtroom thinking, I got away with it, because you're going to be responsible. So there's going to be fines and costs, and you're on probation. Fines of $150. Cost of $150, crime victims' rights fee of $75, state minimum cost of $50, $90 for the assessment, and then there's an LPD restitution amount. And I'll give you we will prorate the probation to 12 months, which is $360. So let me give you a grand total so you know. So that's a grand total of $1,182.86. Talk to your probation officer about making payments and setting that up, okay?
1,182.
Yeah, $1,182.86. I'm gonna put you on probation for 12 months. There'll be no assaultive, threatening behavior, no use of possession of alcohol, marijuana, or controlled substance. Tell you the truth, that is what gets people in front of me, is the dropping dirty. So, yep. So, and then we start this process going again. So if you're able to avoid that, the temptation of that in any way, you'll be on to your second part of this. No bars or nightclubs. To attend the moral recognition therapy program, attend a 12-step program, not purchase any firearms, ammunition, or weapons. The second biggest thing we see is firearms in district court. That's what we see in the city of Lansing. Conviction reportable to the Secretary of State. We've indicated that. I will tell you this, and I think you're a great candidate for this. If you're able to show that you're successful on probation, you are a candidate for early discharge. All right. So if you do everything you're supposed to, you can request early discharge in the next. That'd be half of the time would be 6 months of time. You have to do everything you're supposed to. I'm going to get you to sign this document so you're aware of it. Just know that when I see there's 2 probation officers with me. There's Brendan Hanna and there's Mary Ledesma. When I see them, and I see them twice a week on hearings like this, I'm going to ask them how you're doing. All right. I'm just going to ask them how you're doing. And the minute that they tell me, look, I got some concerns. I also see Ms. Sutter quite a bit here. We're going to be on top of it. All right. I mean, it's so important that you take care of this in the next 6 months or a year, so that we're not back here 3 years from now with the same problems. Okay. This is the time to grow from this and to get it behind you. All right. On some level, to get it behind you. All right. You must have better things to do with your time than to be here on a Tuesday afternoon with me. Absolutely. Okay. So let's work on that. So that is the sentence of the court. 12 months probation. You'll go to probation right after this, and answer any questions they have, and they'll put you on probation to them. I am also amenable that I don't want anything duplicative. So if you're going through some type of alcohol assessment or any type that in regards to the letter, then we shouldn't rework the wheel. I don't want to overprogram you is what I'm saying, okay? I want to make sure we have the right program for you. It doesn't help you if we have too many programs for you, okay? And we'll keep an eye on that. It's not, is it on here? I don't see it. Recommended. More recognition. 12 step. As directed. Okay. Yeah, so, yeah, he does have he also has X. Submit to random PBTs and urinalysis, which goes along with not dropping dirty. Ms. Sutter, if you'll have your client sign this. This is the advice of rights for the probation or early discharge.
I don't need to steal a pen. I seem to have brought a pencil with me today. Thank you.
You're welcome. Thank you, Ms. Sutter. All right, Mr. McNeely, hopefully we won't be seeing a lot of each other, okay? But in the meantime, if you do what you're supposed to do and you contact and you stay with your probation agent, any contact we have will be good contact, right? All right, good luck to you, sir. Okay, thank you.
Thank you, Your Honor.